I was grieving whenever I committed these crimes. My mom just passed away a year ago, this last month, just passed away. So I wasn't in the right state of mind with these crimes. I wasn't thinking about anybody. I was being selfish.
She walked into court believing a tragic family loss was her ultimate get-out-of-jail-free card, but she severely underestimated who was sitting on the bench. Melissa Paez is caught dead to rights. She's facing up to 20 years in a Texas prison for a massive financial fraud scheme, including hoarding dozens of stolen credit cards. But Paez has a plan. She's going to look the judge in the eye, blame her calculated felony crime spree on the grief of losing her mother, and ask to walk right out the front door on probation. But grief doesn't forge credit cards. Watch closely as a seasoned judge listens to the sob story, asks one pointed question about where her children were during this crime spree, and realizes the excuses just don't hold up. Will this mother's desperate plea for mercy actually work, or is the gavel about to fall hard?
Court is calling 2025 CR 008396 and 2025 CR 014167, State versus Melissa Renee Paez. Can I have parties announced for the record?
Trey Maurer for defendant.
All right, and are you Ms. Paez?
Yes.
Counsel, in each cause number, have you received all discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. In each cause number, Ms. Paez, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it?
Yes.
And did you sign it? In each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictments as presented in cause number ending in 9-6?
No, Your Honor, state moves to waive the enhancement allegation as well as count 2 and proceed solely on count 1.
Any objection?
No objections.
And are you proceeding on the indictment as presented in 6-7?
No, Your Honor, state also moves to waive the enhancement allegation in that clause.
Any objection?
No objections.
All right, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
In cause number in 9-6, you're charged with fraudulent possession or use of credit card or debit card, 10 to 50 items as a second-degree felony, range of punishment. I'm sorry, you're only proceeding on one count, correct?
Correct.
Okay, it's just the way it's printed out. We're good though. All right, the range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, sir.
If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. In the cause number ending in 6-7, you're charged with false statement to obtain property or credit, $30,000 to $150,000 as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, sir.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, sir.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Paez, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, sir.
If you're not a U.S. citizen, by entering into these pleas, you will be deported, denied naturalization, or reentry. Did you understand?
Yes, sir.
In each cause number, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. In each cause number, the state is waiving the enhancement. And in cause number ending in in the cause number ending in 9-6, the state is proceeding on count 1. And in each of the cause numbers, the state is asking that your punishment be assessed at 10 years in the prison. There's a $1,200 fine, State is opposed to your application. They're asking that the causes run concurrently. They're taking in consideration 2025 CR 014168, 2025 CR 015020, and 2025 CR 015019. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State? And each cause number, did you review the waiver of appeal paragraph? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
There were not, Your Honor.
And the cause number ending in 6-7 outside the agreement, there's to be no contact with Mission Mitsubishi at 9800 San Pedro, and there's to be no contact. Did you understand those were recommendations from the state, and the court does not have to follow that recommendation? Then in cause number 2025 CR 008396 to count one, how do you plead?
Guilty.
And in cause number 2025 CR 014167, how do you plead?
Guilty.
State, in each of those cause numbers, do you have any evidence to support the plea?
Yes, Your Honor, state offers State's Exhibit 1 and all attachments in both causes.
No objections.
All right, state, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, in each cause number, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, the state is opposed to your application. If you would like a PSI and a TAP evaluation, it'll be 8 to 12 weeks. If you would like it brought back sooner, I will listen to whatever witnesses or evidence that's submitted to me and make a decision.
Your Honor, after speaking with my client, we have a request if the court would consider signing the dismissals on the 3 cases that were taken into consideration in light of her plea of guilty and plea onto these 2 cases. If those 3 cases are closed out, and if the court would additionally consider reducing her bond slightly on the 2 that she has pled on, so she could take those full 8 to 12 weeks, organize her witnesses and people that she would like to be here on her behalf, and make sure that she has everything lined up for whatever the court does decide at that point. I believe that's what we are requesting, Your Honor, if the court would consider dismissing those 3 and possibly just slightly reducing the bonds on the 2 that she's pled on so she can organize everything and take the full time for the PSI.
All right, so with regards to bond reductions, you'll have to file a motion and then I'll hear it so that the state can be prepared.
Okay.
And if the state is waiving notice, just whenever you all get together, the court will do that. Now, with regards to the dismissals, any objections to the court signing the dismissals now, or?
Object, Your Honor, because that is something that ensures or will be dealt with at the resolution depending on what this court does.
And maybe I should have discussed this with you beforehand. If I may say, Your Honor, I've understood previously that if someone enters a plea and then does not return, that that plea can be, the court can say we're not going to accept the plea and that the full range is open. I believe that on its own will be sufficient to guarantee that she'll be here, and she'll accept whatever the court decides at that point.
All right, so this is what I can tell you all. This is new to me. With regards to the court signing the dismissals, the signing of dismissals to the court appears to be a part of your plea bargain agreement. And until the plea bargain agreement is accepted by the court, which it hasn't been accepted, right? The only thing that I'm doing is memorializing for the record that this is your plea bargain agreement. I have not accepted it yet. However, again, it's novel to me. If somebody brings me some case law that says that the court can make a decision with its own discretion to dismiss cases if a plea bargain agreement has been entered to but not accepted by the court, I'll consider it. But my understanding of the law is that unless the state says they're in agreement to these cases being dismissed now, they're really not to be dismissed now. Because your plea bargain agreement, I haven't even accepted it yet and entered a sentence. I've just accepted the contract that you want to enter into. Do you understand? All right. So, but again, if somebody brings me case law that says something differently, I'll review it. I never said I know everything.
We take a quick step back just so I can discuss with my client very briefly, Your Honor.
Sure. And then let me know if you all want the 12 weeks or not, 8 to
Okay.
12 weeks or not.
Thank you, Judge.
Sure. I like to make sure that I hear everything. And this is what I tell people about judges. Well, about me. I don't claim to know everything. I don't know every law under the sun. But if somebody brings me some law that says, Judge, you're incorrect, I'll listen to it and change it. Or if it's something that's novel, like that is novel, that's the first time that's been brought. But if he brings me case law and says, oh, no, Judge, it's within your discretion, then I'll hear it. Yes.
Your Honor, my client has decided to do not the full PSI. Will come back sooner rather than later.
All right, so let's go. We're back on the record. If you'll come forward. All right. So are you asking that the PSI be waived? All right. And then with regards to TAP evaluation, are you asking that that be waived as well?
Is it going to be the same wait time, Your Honor?
Vashon, how long is TAP just for a TAP evaluation? TAP evaluation is 4 weeks.
We'll do the TAP evaluation, Your Honor.
All right, so there is a request for a TAP evaluation. It's in both cause numbers. It's 2025 CR 014167 and 2025 CR 008396. All right, Ms. Ferguson, what date? Yes, and Ms. Abrams, if they can expedite that and maybe get it to us sooner than 4 weeks, we'll try.
I can do February 25th. Oh, I'm sorry, the 26th, Judge.
February 26th. And if for some reason, if they're able to do it sooner, they'll let your attorney know.
Yeah.
All right, you're welcome. Is there anything else?
Nothing for prevention.
All right, with that, we'll close the record.
Thank you, Your Honor.
All right, the court is calling 2025 CR 014167, State versus Melissa Paez. Can I have parties announced?
Robert Maurer for defendant.
And are you Ms. Paez? All right, you entered a plea of guilty on January 21st. The enhancement was waived. The PSI was waived. The TAP evaluation was expedited. Counsel, have you received, and State, have you received the TAP evaluation?
We've received it, Judge.
Any objection to the TAP evaluation, State or defense?
No.
Then according to your plea bargain agreement, punishment is to be assessed at 10 years in the prison. There's a $1,200 fine. State is opposed to your application. This is running concurrent with 2025 CR 008396. The state is taking in consideration 2025 CR 014168. Was there a plea on the 2025 CR 008396 case?
Yes, please.
Could I have the plea paperwork on that, please?
Second
Yes, there are
defendant.
2 cases.
Yeah, I'm sorry, I wrote down the one.
No problem.
What's her name?
Paez, P-A-I-Z.
All right, and the court is also calling 2025 CR 008396 as well. And State, do you have any witnesses you're opposed? Defense, any witnesses you're opposed?
No, Judge.
All right, State, you're opposed. I'll hear your argument, but before we do that, for the record, and cause number 2025 CR 008396, there was a plea of guilty to count 1. The enhancement in count 2 was waived without objection. And according to the plea bargain agreement in that case, Punishment is be assessed at 10 years in the prison. There's a $1,200 fine. This case is to run concurrent with 2025 CR 014167, taking in consideration 2025 CR 015020 and 2025 CR 015019. All right, the court will hear argument.
She would be a good candidate. She's done 2 trips to prison in the past, but more importantly, crimes she's had in her history of crimes of moral turpitude. She's also involved with information. Based on the TAP evaluation, it appears Ms. Paez is not motivated, and in the state's opinion, motivation is the biggest driving factor for someone to be successful on probation. So because this is reasonably less.
All right, defense.
Judge, I spoke with Ms. Paez and she wanted me to speak on her behalf. So she informed me, and I think it's noted in the TAP evaluation, she has 4 kids and they're currently in the custody of the father-in-law. And apparently she had congenital heart failure and epilepsy. So while she was in the hospital, the kids were removed from her custody. I would anticipate if the court grants her release, there's gonna have to be some sort of CPS plan before she can get custody of the kids. She informed probation, informed me she planned to live with a friend of hers. She did mention, I mean, she's had prior criminal convictions for probation for drug use and indicated use of amphetamines and marijuana. But according to the TAP evaluation, none for 5 years. She would like to ask the court for probation so she can get out, try to take care of her kids and give her a chance to get back on track and hopefully stay out of trouble. So I'd ask the court to grant her application for probation.
All right, is there anything you wish to say?
I would be.
Well, here's the thing, before you say anything, I would have to place you under oath and the state would have an opportunity to ask you questions. So do you wish to say anything?
It's up to you.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, I'm gonna need you to speak up so I can hear and probation can hear. And so that the state can hear. All right, if you'll state your name for the record.
Melissa Paez.
All right. Whoever
Melissa,
wishes to
what would you
proceed.
like to tell the judge about why you think you should be given an opportunity of probation?
I think that I should be given an opportunity of probation because I have been incarcerated twice in the past, but I do have children out there and I do want to be in their lives. The only way I'm going to be able to get back in my children's lives is if I get back on the right track. And in order for me to do that, I know what the consequences come if I take this probation. If I mess up, I know that I'm going to have to go back and do a lot more time. So I know that. But the longer that I wait to get my life on track, I'm not going to be able to have my kids back. And I need to do that. When I get out, I have 2 job offerings, one at a Bolero and one at a hotel. Both of my friends are offering me jobs there immediately. And I have no issue with submitting drug urinalysis. I have no problem doing none of that. And I just would like to be given that chance.
Pass witness.
Any questions?
Ms. Paez, you mentioned your children. Were you thinking of your children when you committed your offenses?
No.
How is the court to believe now that you're gonna use your children as motivation?
I would
be successful on probation.
I was grieving whenever I committed these crimes. My mom just passed away a year ago, this last month, just passed away. So I wasn't in the right frame of mind with these crimes. I wasn't thinking about anybody. I was being selfish. Thank you.
I don't have anything further.
All right, I have a few questions.
Yes, ma'am.
So I don't understand how your grieving translates into your committing crime. And the reason why I'm asking, I'm trying to understand your thought process.
Hey, when my mom passed away,
Does anybody have any Kleenex over there? Okay.
my mom passed away, I can admit that I just spiraled down just immediately after she passed away. Like I couldn't handle it. Like, and then I needed help paying for my brother's bills whenever I got out because I was living with him. I rolled out to Bevo, and I just got into something that was easy and it just stuck. And that's why I did it, because I just wanted to help, but drugs was never my addiction problem. It was the fact that I needed to help and I couldn't, but I
I'm
was
so sorry. Excuse me, miss, you're gonna have to take a seat. All right, you may continue.
I was grieving, and I can admit that I did start doing drugs, but like I said, drugs has never been my thing. So when I did that, it's just like when I got stuck doing that one thing on that drug, that it just kept going from there, and I just kept
And
going.
where were your children doing all of this?
They were my father-in-law. But my father-in-law again was telling me that I couldn't get back into my children's life until I was stable, and I understood that. But again, I was grieving and I started doing drugs, and I just, I got stuck in that predicament. And my where I pull out to is Bevo, and they're over here in San Antonio.
So your parole offers what?
I pulled out to Bevo where my mom lived,
Mhm.
and my kids are here in San Antonio.
Okay. All right. Anything else?
No.
All right, so here's the thing. I don't think you're appropriate for probation, so I'm not gonna grant your application. What I'm gonna do is I'm gonna find you, and cause number 2025 CR 014167. Court is gonna find you guilty. The court will sentence you to a $1,200 fine. Time and money will run concurrently. Court will request the therapeutic community. This will run concurrent with 2025 CR 008396. Take in consideration 2025 CR 01468. There's to be no contact with, I'm sorry, state, you may be excused. There's to be no contact with Mission Mitsubishi at 9800 San Pedro. And Charlene Hill. There's to be no unsupervised contact with minors. And the court will sentence you to 9 years in the prison and give you credit for any time served. And that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. In cause number 2025 CR 008396. The court is going to find you guilty. Court will give you credit for any time served. Court will sentence you to 9 years in the prison. Give you credit for any time served. There's a $1,200 fine. Time and money will run concurrently. Concurrent with 2025 CR 014167. Taking consideration 2025 CR 015020 and 2025 CR 015019. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? And I'm sorry, the court is also going to order the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. The therapeutic community is designed to help you with whatever issues you may have. It's to help you hopefully come back into society, rehabilitated and be successful, and not get sent back. I don't have any jurisdiction to force them to place you in the program, but in the judgment, it'll see that the court requested the therapeutic community. It won't increase the time that you're in custody, and you'll need to request it as well. Do you understand? All right, good luck to you, okay?
Thank you, Judge.
Thank you, counsel.
No probation, no free passes. Judge Boyd saw right through the excuses and dropped the hammer. She sentenced Melissa Paez to 9 years in a Texas prison on both felony charges to be served at the same time. She also requested Paez be placed into a strict therapeutic community behind bars to finally address her drug addiction. Losing a parent is a profound human tragedy, but it is never an excuse to steal from innocent people and abandon your responsibilities. When you try to manipulate the justice system by weaponizing your own grief, a good judge will spot the deflection from a mile away. Today, common sense prevailed over a calculated sob story. Do you think a 9-year prison sentence was the right call for these financial crimes, or do you think the judge should have given this mother the second chance she begged for? Let us know your thoughts in the comments below and subscribe for more real stories from the courtroom.